In Ray Bergman, 115448.
May it please the court. Kate Baird appearing on behalf of the Disciplinary Administrator's Office. Justice Lukert, may I reserve 2 minutes for the purpose of rebuttal?
2 minutes is reserved.
Thank you. As the court's aware, this final matter before the court this morning is an original proceeding in attorney discipline. A Kansas hearing panel convened back in January of this year and considered evidence relating to the alleged misconduct by the respondent. The respondent, prior to the hearing, stipulated that a Missouri Supreme Court order of May 26th of 2015 finding that she violated Missouri Rules of Professional Conduct 1.7, 1.8, 1.13, and 8.4c was conclusive evidence of professional misconduct for the disciplinary proceeding here in Kansas pursuant to Kansas Supreme Court Rule 202. The disciplinary administrator and the respondent jointly recommended to the panel that they adopt the imposition of discipline imposed by Missouri at the hearing panel. The professional misconduct of the respondent arose out of her actions as counsel for the complainant, Kansas City Terminal Railway Company, a Missouri corporation. The respondent was a member of a Missouri law firm and had provided legal counsel to the railway company from 1999 and then as general counsel from 2007 to 2012. Her services were terminated by the corporation in 2012, the same year that the corporation filed disciplinary complaints both in Kansas and in Missouri. By way briefly of process, both complaints were set for investigation. Disciplinary investigation was initiated on both sides of the state line. In October of 2013, the Missouri Bar Council filed a formal complaint. At that time, the review committee for the Kansas Board of the Discipline for Attorneys set our complaint on hold. They directed that our matter be held pending disposition of the Missouri matter. The Missouri complaint proceeded to a contested hearing in May of 2014. The matter was briefed and argued after Missouri panel made findings and was submitted to the Missouri Supreme Court and argued to the Missouri Supreme Court. The court found, as was noted, that the respondent had engaged in multiple violations of professional misconduct, ordered that she be indefinitely suspended, but granted probate, stayed that the imposition of the sanction, directing that she be placed on a 2-year probation. At that point, our review committee moved the matter off of hold and directed that our office file a formal complaint, which is what we certainly did at their direction. The Kansas panel, after hearing evidence in January, determined that the respondent violated Kansas Rule of Professional Conduct 1.7 when she continued her representation of the Kansas City Terminal Railway when there was a substantial risk that her representation would be materially limited by a personal interest in and relationship with one of its constituents without obtaining informed consent, that she violated 1.8 when she developed a personal and sexual relationship with a constituent of her client after the establishment of the attorney-client relationship, that she violated KRPC 1.13 by failing to address or report substantial injury to the client involving the diversion and appropriation of a rail car purchase.
Would you highlight the circumstances of the purchase of the rail car? It's not real clear to me exactly what occurred here, but there were, in essence, KCT funds used to make a private purchase of the car, or a kind of a different entity, Tallgrass Rail Cars. Just explain to me what happened.
Well, and I'll refer the court to the findings page at 27 of the hearing panel report, findings 49 through 67.
Right.
Those focus on the issue with the rail car company. This is back in 2007. Counsel was, the respondent was counsel for the railway company. They were beginning to look at the purchase, whether or not it would be better to purchase or lease a rail car. The constituent of the company with whom the respondent had a personal relationship, and another member of another constituent at the same time, or at or near the same time, purchased a rail car. The railway company, the client, purchased the rail car, not knowing that it was owned by the two constituents of the corporation. And the two constituents of the corporation then tried to lease the company, or entered into a lease agreement that was never executed between the railway company and the owner of the rail car. Does that make, I don't know if that makes much sense.
I'm just trying to determine if corporate funds were basically used to acquire the rail car.
Maybe not
For
in the
personal
acquisition,
use.
but in the refurbishment,
Right.
They were used in a refurbishment of the rail car.
even though it was owned by an entity other than the rail company?
Yes.
Railway company?
At that point.
And if I'm not mistaken, weren't the facts also that the respondent may not have personally participated, but directed participation by her firm in the negotiations on behalf of the railway company for this purchase or lease at the same time that the firm was creating a separate entity for these two
Yes.
constituents?
Yes.
Okay.
And I wanted to make sure, in response to your question, that the purchase of the rail car was not actually made by the railway company, but the purchase was by a corporation that the client had they used this corporation, Watco, for virtually all of the services provided to the railway. So it wasn't the Kansas City Railway Company that purchased the car, but it was a company with whom they had a consistent business relationship and relied on for all of the services provided by the railway company. The billing, as was mentioned, the panel concluded that there was billing, that the respondent billed the client for work that actually was performed on behalf of the Tallgrass Corporation that was owned by the constituent, Mr. Mader, with whom she had a relationship.
So there was a joint recommendation of discipline at the panel level.
There
You
was.
say there was a joint recommendation, and the panel actually ended up recommending indefinite suspension. Is that correct?
They recommended indefinite suspension
Something substantially, and with no probation,
with no probation.
right? So what is the recommendation of the disciplinary administrator as of today?
Nothing has changed that would warrant an increase in the recommendation that we made at the hearing.
So you don't think there's a necessity for indefinite suspension to be imposed immediately?
No. And I'll inform the court how that decision was made in a reciprocal discipline case. I did consider that the matter was fully briefed, fully considered by the Missouri Supreme Court. I considered whether or not there were any factors unique to the Kansas case, whether there was anything here in Kansas that warranted a recommendation other than what the Missouri court had ordered, and concluded that there were no factors that warranted an increase in the recommendation
Something
made.
harsher than what they did
Yes.
in Missouri. Do I understand the Missouri sanction to be that at the conclusion of successful completion of 2 years of probation, then the suspension would never be imposed and the case would be closed? Is that how it will work in Missouri?
That's my understanding.
Okay, and where are we in that 2-year period?
May of 2017 will conclude the probation period.
Okay, thanks.
And do you disagree with the rationale of the hearing panel as to why they recommended a more severe sanction?
I don't know that I disagree, but I think I would have given greater weight to the Missouri Supreme Court, having had opportunity to fully assess the facts and the arguments made before it. In the Missouri rule of probation, there needs to be, for eligibility to be established, there needs to be a determination that the lawyer doesn't pose a risk of engaging in further misconduct. I think that's persuasive. There was a mitigating factor that was present in the Kansas case to some extent that was not present in Missouri, and that was there was an acknowledgement, even though I understand the panel did not conclude that the respondent took full acceptance and responsibility for her conduct. There was an acknowledgement of misconduct, an acknowledgement that there's been a finding of misconduct, and that was not apparent and did not exist in the Missouri case. So there was one mitigating factor in Kansas that was not present in the Missouri matter.
But the Kansas panel had the opportunity to view respondent, pose questions, and they posed questions about this acceptance of the propriety of her actions, determined that she acknowledged that the rules said that she did something wrong, but they didn't believe her to have internalized the fact that something had been amiss in her conduct. Would you agree with that characterization?
Yes.
And why isn't that something different than was at Missouri? If we have our panel members have made that assessment that she really hasn't accepted the fact that there was any wrongdoing, which would impact the effect going forward, the effect of probation. Why isn't that something different in Kansas than was in Missouri?
That was the position that she took in Missouri. She contested the misconduct at the panel hearing as well as in the argument to the court. So that was a factor, an aggravating factor, if you will, that existed in the Missouri action also. there was an absence of acceptance of responsibility. And that factor, I have presumed that that factor was a factor considered by the Missouri Supreme Court when they reached the conclusions that it did.
So, did you have a question?
Do you, I presume you disagree with the panel's finding that probation's not in the best interests of citizens of Kansas? And if you do disagree with that, can you explain why?
One of the factors where I think that the citizens, we can hopefully presume the citizens are protected, as maybe in any probation, there's an elevated, perhaps we may presume there's an elevated sense on the part of the person on probation of the obligation to maintain their conduct within the rules because of the sanction that might be imposed. I think inherently, hopefully in every probation that exists. I also think that there may be I go back to the court concluding under Missouri rules that they made the decision that she's eligible and that there is not a likelihood that the respondent would engage in further misconduct.
So, what is your request for an underlying sanction that would be suspended for the probation? Is that what, or is that the nature of your recommendation?
Well, I've thought about that. Our agreement, and I agreed as we presented the matter to the panel to defer to the Missouri order. The Missouri order was indefinite suspension with the opportunity to petition for reinstatement after 2 years, and then a stay of that suspension for the period of the 2-year probation. If the court accepts the recommendation of the hearing panel, we have indefinite suspension, and under our rules, that would be a 3-year period of time before a petition for reinstatement could be made, and under our rules, a reinstatement hearing would be required. I don't really want to change we did agree to submit the matter, but I think as a practical matter, what may be an appropriate underlying sanction would be a 2-year definite suspension, which would be more comparable to what the Missouri court has ordered when you look at our sanctions, without the need for a reinstatement hearing.
Are there other questions? All right.
Okay,
Thank you, Councilman.
May it please the court, James Eisenbrand on behalf of the respondent, who is likewise present here in the court. I want to preface my comments by saying one important thing. I am not here in any way to say that this is not extremely serious. I do want to try to clarify a couple of things, perhaps one of which is the questioning that you all presented on Tallgrass. What happened with Tallgrass is that the president of KCT, who was a Mr. Somerville at the time, in mid-2007, came to Ms. Bergman and said that KCT needs to buy a rail car. These rail cars are used primarily for entertaining. All the large railroads have them. The large railroads are the owners of KCT, and Mr. Somerville felt that there should be that KCT should have a rail car. Until mid-December of 2007, the record that was developed in Missouri is very clear that KCT was the purchaser. And the documents that were drafted during that period of time reflect that. That's what Ms. Bergman's instructions were. What happened was, and I don't want to get into quibbling about evidence because that's improper where we're standing, but I just want you to understand. What happened is that Mater and Somerville, in the latter part of December, found out from Union Pacific, which is one of the owners of KCT, we're not going to let you, KCT, purchase a rail car. And so they went out on their own to purchase a rail car. And that is the context in which the purchase agreement, Ms. Bergman's position was that she believed Tallgrass to be a subsidiary purchasing device by KCT. And that turned out not to be the facts. And the Missouri panel admittedly did not accept that, but that's the context in which this all came up. The allegations of using KCT money to by Tallgrass to purchase the rail car, that was not a part of these proceedings. The allegations in count 3 of the Missouri complaint or information, which is, I believe, Exhibit 1 of the disciplinary administrator. The allegations essentially are that she failed in her professional duties because she couldn't serve 2 masters. There was an allegation in that count that Lathrop and Gage, through Ms. Bergman, had billed improperly KCT for the services rendered on the rail car. And the hearing panel in Missouri found that under Rule 1.5. If you look at the Missouri Supreme Court order and their findings, they did not make that finding that these were unreasonable fees. That is not in the findings of the Missouri Supreme Court. That, in essence, is Tallgrass. Another thing that I want to clarify, and frankly, this didn't occur to me until I was preparing for today. Finding 30 by the Kansas panel indicates that Ms. Bergman had submitted the plan of probation to Missouri, and Missouri accepted it. That is not correct. No plan of probation was submitted at any time in Missouri or to the Missouri Supreme Court. The Missouri Supreme Court, as a part of its order and its findings on May 26, 2015, itself directed the probation. It set the terms and conditions of probation. This was nothing that we submitted as some kind of slap on the wrist to get her through. That's not what happened here. That was the Missouri Supreme Court as what they deemed to be proper for probationary terms. And there's no question she has lived up to those in spades. But it was not at our request. Another thing that I'd like to clarify a little bit.
Mr. Eisenbrink, may I ask a question about that?
Of course.
This is a Missouri procedure question again.
Okay.
Does it work similarly to this, where there's a hearing before the court and the respondent and her lawyer are permitted to address the court? And if so, and I don't know that it is so, but if so, did you make any kind of recommendation of sanction in that proceeding?
Okay. I did not personally handle the
Okay.
proceeding in front of the Missouri Supreme Court. I have listened to the arguments. I was involved. I saw the pleadings, that type of thing. But I personally did not make the argument. I was not there. But no,
Okay.
no.
There was no recommendation at all?
This was based on the law and the facts. That's what the argument was about.
Okay, thank you.
One of the findings made by the Kansas panel as a result of letters that we submitted from present clients and an organization, a charitable organization with which Ms. Bergman is a part, they made a finding the respondent is an active and productive member of the bar of Metro Kansas City area. She enjoys the respect of her peers and generally possesses a good character and reputation as evidenced by the several letters presented. And this is the reason, or one of the reasons, that we have requested probation under the terms and conditions in Missouri, is while she does not have clients at this moment in Kansas, her practice is in the metropolitan area. And incidentally, at the time all of this arose, she was representing the city of Coffeyville. And that representation is complete now, but she does from time to time come to the Kansas side. And that's the reason we have asked for the probation. She has cooperated fully in the Kansas proceedings. At the request of the disciplinary administrator, we spoke to, as did the administrator, with a lawyer in Johnson County by the name of Lori Hodenpile, who is a lawyer of some 20 years experience in Lenexa, to serve as a liaison. And she has again confirmed that she is willing to work as a liaison, should that be a part of any order to coordinate between Missouri and Kansas. On this issue of acceptance of responsibility, and I know that that is something that created issues before the hearing panel. And not to just pluck out exchanges, but I guess candidly that is what I'm doing. Among the things that she was asked in that regard was, and this is a questioner, I'm asking you again. I'm sorry, I'm asking you if you agree that there was a violation. And her answer was, I agree under the rules there was a violation. And the response was, okay. Then there were further discussions about that. But what I guess I'd like to put this in context. When we started this process some 4 years ago, we were served with a complaint in a binder, about a 4-inch binder. and we started going through it, trying to find out what the complaint is all about. In Missouri, there are preliminary panels that make the determination of probable cause. In Jackson County, Missouri, there are 3 such committees. 2 of them actually conduct hearings. 1 of them only meets and considers what's in the complaint and the rules are such we have no right to be there or present anything. We do the panel that does no investigation, and that's what resulted in the information that was filed. We had good faith legal positions to take on some of these events. Some we won, some we lost. We had factual disputes on the charges. Some we won, some we lost. For example, on the Rule 1.8K, sex with a constituent, there was no law on this. The rule, as to individuals, well, I can't even qualify it as that. The rule says that if the sexual relationship commenced prior to the attorney-client relationship, that's a get-out-of-jail card free. There is a comment in the corporate setting that just says, thou shalt not have sex with a constituent. Miss Bergman's relationship with Mr. Bader was not a fling. It was a committed relationship which started years before he became a constituent. He worked for a company that was a consultant, and that's when the relationship started. At the time, Miss Bergman was the attorney or an attorney for KCT, but he was not a constituent. And I believed that there was a good faith argument, which we frankly were hoping we could get a court to decide on that issue. And we lost, but we never got a court determination. So we're stuck with that. Count 2 was dismissed by the panel. That was breach of professional conduct with regard to Mr. Bader's contract. The panel in Missouri found that there was a lack of evidence and it was abandoned. I've already mentioned the Rule 1.5, which the Supreme Court did not find. Count 5 or 6, alleged fraud against Lathrop and Gage. That was dismissed on the morning of trial. I'd like to think because we did a good job of presenting facts and information to the disciplinary counsel's office. So what I'm trying to say is, and my time is up and I'll conclude, what I'm trying to say is that this was not a case, this was a case with many moving parts. It was like a civil or a criminal case in the sense that there were many, many allegations that were never charged, ultimately. And of the charges that were brought in Missouri, half of them were dismissed either by the panel or at the request of the disciplinary counsel on the morning of our hearing. And again, I want to emphasize that I'm not denigrating the findings or the seriousness. I'm just asking that this court adopt what Missouri did of its own volition as what they felt was proper under the circumstances of this case, and put Ms. Bergman on probation in Kansas also, under those terms and conditions.
And are you asking for any particular date for the beginning date of that probation?
Well, we asked that it be concurrent, so it would be from May 26th, May 26, 2015. That's what we requested.
Thank you.
Thank you.
Just a second, Counsel. That's a 2-year probation, but it requires a petition for reinstatement in Missouri?
It will, yes.
And do they, what's their process for reinstatement? Do they have a hearing?
It's much the same as here. We have to submit an application to the Supreme Court, and they have to grant it.
Thank you.
Actually, that's a part of the order. Thank you.
No questions?
I reserved 2 minutes for rebuttal. Chief Justice Nuss, I reserved 2 minutes for rebuttal. I don't have anything to add unless there are questions of the court.
Any questions?
You concur in that timing, that it should be concurrent with Missouri?
I didn't make that clear at the panel. As a practical matter, that has about 6 months left then, or it's a very brief time. If the court determines that it's appropriate to move beyond that, then I think that the court needs to designate Ms. Hudenpyle as a monitor, because right now the monitor in probation is part of the Missouri Disciplinary Counsel's office.
Any more questions? Thank you, counsel. Thank you all for your arguments this afternoon. Court will take this matter under advisement.